Welcome back, everyone. It's Peter Tragos, the lawyer you know, and today we're going to give an Ethan Crumbley update as things are happening. First, we have determined what the defense might be based on what the defense attorneys are saying. And number two, the judge has made a ruling as to whether or not Ethan Crumbley is going to be transferred from an adult facility to a children's village, which is obviously a much less harsh environment for a child that's just 15 years old. So if you haven't already, take a second to subscribe to our page. And if you enjoy the Crumbley content, make sure you hit like and we will bring more of it to you. So we have heard from the defense attorneys for Ethan Crumbley that they plan to assert a temporary insanity defense with regards to Ethan Crumbley in the Oxford school shooting. Now, they are putting together medical expert testimony, they're putting together documents, and I'm sure a lot of the journal entries and text messages that we've already heard about in this case to compile enough evidence to prove that he was temporarily insane at the time of the shooting, meaning he did not understand his actions and the consequences of his actions when he shot up the school. Now, a lot remains to be seen. We're not going to make any judgment calls on this yet. We haven't seen the evidence. We haven't dug into it, but we are now aware that that is what they plan on doing. At this point, they could still probably change what their defense is, but we're going to go with that for now, and let me know what you think of that in the comments. If you're surprised, write surprised in the comments. If you're not, put the big red X in the comments below if you are not surprised at all that he is planning to raise a temporary insanity defense on these murder charges. Now, the second update has a lot more detail as there was a motion and a hearing filed by the defense attorneys asking for Ethan Crumbley to be transferred to a children's village, and the court has come down with its ruling. And we're going to go through the court opinion today because it is very disturbing the reasons that the court said no. Ethan Crumbley is going to stay in the adult facility and not going to go to the children's village. All right, we're going to jump down to page 7 to get to the good stuff and actually give us the reasoning why the judge said no, Ethan Crumbley is staying in the adult facility. Here, this court cannot find that the juvenile would be safely detained at the children's village. During the placement hearing, Heather Calcaretta, manager of the children's village, testified that she had concerns if the court placed the defendant at the children's village. Specifically, Calcaretta testified that she was concerned that other residents may target the defendant. Moreover, she testified that she is concerned that the defendant's placement at the children's village would cause trauma impact on other residents. She also testified that the children's village is suffering from a staff shortage. Lastly, she testified that the children's village had never had an alleged school shooter and has never had anyone presenting an insanity defense in the children's village. So that's important. First, we know he's accused of a school shooting. Second, we now know that he's alleging an insanity defense, and this person that works at the children's village said, we have never had somebody under those circumstances. Therefore, the adult facility is better. They don't want him at the children's facility, basically, is what the judge is saying based on the testimony of the person that manages the children's facility. They don't have the staff and the resources available to deal with something as high profile and potentially controversial as this. So based on the totality of her testimony, it is clear to this court that the children's village is incapable of safely housing this defendant because of the unique circumstances this case presents. Moreover, after May of 2022, defendant cannot be placed in solitary or be secluded from other juveniles if it were for his protection or for others' protection, because they don't have solitary there. As such, it necessitates that he will be in the presence of other juveniles during class, at the cafeteria, dinner, etc. The ratio of students to teachers will be 1 teacher for every 8 residents. Again, defendant's presence and potential impact on other students is concerning. Additionally, if there was an issue, Calcaretta testified that help may not be immediately available. This court finds Calcaretta's testimony persuasive and places a great weight on her testimony because she is in the best position as manager to determine if the defendant can be safely lodged at the children's facility. As such, the court finds that the defendant cannot be safely detained at the children's village based upon the testimony. Next, pursuant to the JJDPA, this court finds that it is in the best interest of justice to lodge the defendant at the Oakland County Jail for the reasons below. So now he's going to say not only can he not go to the children's village, but there are also reasons he needs to be in the Oakland County Jail, and here they are. The age, 15 years old, the court recognizes he's a juvenile. Number 2, the physical and mental maturity of the juvenile. The court will note that the defendant appears to be of average slim build and is approximately 5 feet 11 inches. Additionally, upon reading excerpts from the defendant's journal, numerous text threads, and having reviewed the defendant's jail records, in this court's opinion, the defendant shows sufficient mental maturity. Now we are about to get to the disturbing parts. Number 3, the present mental state of the juvenile, including whether the juvenile presents an imminent risk of harm to the juvenile. So these are the elements and tests basically the court goes through in making their determination. The defense argues that the defendant is suffering from extreme isolation and that the isolation has a negative impact on the defendant's mental health. Christina Belling, defendant's jail counselor, testified the defendant is on a behavioral watch and no longer on suicide watch. She stated that she would not have changed the defendant's status if she believed he was a danger to himself. Moreover, this court read the defendant's email exchanges since being lodged at Oakland County Jail, which we're about to get to, but that's an important distinction. We've talked about what suicide watch is. You go and you have paper clothing, so you can't do anything to hurt yourself. You go in a jail cell with no sheets and nothing that could be a tool to use in suicide. There's a lot of people going through a lot of things there, screaming all night, having nightmares, having visions. It's a pretty scary place to be on suicide watch, but now he is just on behavioral watch, which is not as serious according to this person. The court will note that the defendant has been actively communicating with members of the public. So don't forget, all communication, phone calls, letters, emails, as long as it's not with your attorney, are going to be read, opened, and looked through by the jail staff. So this court has had the ability to read through everything that he has been doing and contacting the public, which he said here, several times a day sometimes. Throughout the email exchanges, defendant does not express any mental health concerns. In fact, in an email dated January 16, 2022, defendant emailed an individual that he is in adult jail and I got a cell to myself, 3 meals a day, a TV to watch, and the guards are pretty nice. Doesn't sound too horrible. This court reviewed numerous jail email exchanges and will note that the defendant does not express any mental health concerns. So he's writing all these emails, he's talking to all these people about his situation and not raising any mental health concerns. Additionally, upon reading the defendant's jail email exchanges, the court will note that the defendant advises others that he's doing fine and expressed positive thoughts through the exchanges. For example, in an exchange dated January 19, 2022, defendant advises an individual that their mail brightens his day and photos of New York are what he imagined. There is nothing in the email exchange that causes the court concern over the defendant's mental health. And again, this doesn't affect the insanity defense because that's temporary insanity at the time of the crime. This is not about the insanity defense because that's temporary insanity at the time the crime was committed. This is about his mental health right now, being in the adult jail, being in solitary, what he's dealing with, what he's going through. Does it rise to the level that they need to move him to the children's village with all of the issues and concerns with the people that manage the children's village? And it's a balancing act. Clearly, the court says no. He is eating, reading books, playing video games, and talking to others. As such, this court is not persuaded that the defendant's isolation is having a negative impact on his mental health. The nature and circumstances of the alleged offense. Again, more disturbing news. The nature and circumstances of the alleged offense are extremely troubling and disturbing. The court is placing great weight on this factor, and the people allege that the defendant planned and executed a mass murder at Oxford High School. Allegedly, he killed 4 students and injured several others. The alleged facts speak for themselves, and there's no need to analyze this further. So they are so bad, we don't even have to waste time analyzing how bad and disturbing the facts of this case are. That's a major factor in determining where the defendant should be housed in a children's facility or an adult facility like the county jail. And the county jail is where they put the worst of the worst, and the court's basically saying these facts are the worst of the worst. Lastly, and here's some new information that I didn't know all about this, but the court is taking into account the disturbing history of the juvenile. The juvenile's history of prior delinquent acts. This is a factor the court has to consider. Upon review of the people's exhibits, the court will note several prior delinquent acts. First, this court reviewed text messages that occurred several months before the alleged incident. Additionally, this court reviewed excerpts from the defendant's journal, which we've heard a lot about. In the course of those threads, defendant texted another individual and wrote in his journal that he planned to kidnap, rape, torture, and then kill an identified minor female. That's what's in these text messages. Additionally, in the journal, the defendant describes that he had created Molotov cocktails and he started a small fire in the woods. Further, he described that he may use the Molotov cocktails during the school shooting. Very disturbing and concerning. Lastly, the court will note that prior to the alleged incident, the defendant killed several baby birds. In his journal, the defendant noted that he killed 8 infant baby birds by slowly torturing them to death. The court reviewed the people's exhibits, which indeed shows the defendant torturing a baby bird to death. The above prior delinquent acts are of grave concern to this court. If that's not enough to house him with the worst of the worst, I don't know what is. When you have a history like that, and you're accused of a crime like this that people know you committed, and the insanity defense is admitting that you committed the act. Now, whether or not you were insane at the time is a different story, but you're admitting committing this horrible act with all these prior delinquent acts. You're not going to get the easy way out. You're not going to get the children's village with other kids that are there for stealing a stick of gum. They're not actually there for stealing a stick of gum, but much less serious acts. The relative ability of the available adult and juvenile detention facilities to not only meet the specific needs of the juvenile, but also to protect the safety of the public as well as the other detained youth. Now, this factor and then the last factor, any other relevant factors, basically go through again the testimony of the person that manages the children's facility and the fact that he seems like he's doing fine with his bed and his food and his TV and his video games and his books in the adult facility, and the guards are pretty nice to him. So while the court is balancing all of this, children's facility can't handle him. Adult facility seems to be handling him fine. His mental health seems like it's fine in all of the contact that he has with the outside world, including the public. And additionally, the very disturbing acts that he's accused of and the delinquent acts that he has committed in the past, seems like this was not even a tough decision for the court. They said he's staying where he is, he's not moving to the children's village, and let me know in the comments if you agree. And the comment below, either children's village or adult facility, where you think is best for Ethan Crumbley based on those factors and based on the facts that we know that the court considered in this case. In my opinion, the court got it right. Leave him where he is. No need to put the other kids at risk at the juvenile facilities. No need to put the facility at risk, the staff at risk. Leave him where he is. He seems like he's doing fine. That's just my opinion. I want to hear from you. But that's all we've got on the Ethan Crumbley update. Let me know if you have any other questions or if anything pops up in this case that you want me to break down. I'm here to provide the content you're interested in. Like the video on the way out. Until next time. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.